Okay, today we're going to talk about harassment in the workplace, with our vocabulary words being 1. Harassment, unwanted attention or referencing concerning a protected class. Unwanted attention or referencing, saying things, doing things that's covered by a protected class. Hostile work environment, when harassment becomes illegal and is actionable by the government and courts. Okay? So when harassment becomes so bad, it becomes illegal and the government can step in. And at that point, it is called a hostile work environment. Now, it is important to know that all harassment is actionable and punishable by your company according to the company rules. So even if it doesn't rise to the level of actionable hostile work environment where the government's going to get involved or the courts, even smaller things of harassment could be punished, disciplined, addressed by a company. In previous lessons, we've talked about discrimination. This lesson is on harassment. Related to discrimination, discrimination is actions based on protected class, work decisions based on protected class. This lesson is harassment, which is targeting someone, making someone feel uncomfortable based on their protected class. And in future lessons, we take harassment and put it into the sexual harassment realm, which is roughly the same as harassment, but instead of protected class, it's of a sexual nature. So here are some categories that, when engaged upon, if they are offensive, reasonably offensive, and someone takes offense, and they cover a protected class or about a protected class, could be harassment. It could be insults are the most obvious one. Insulting somebody based on their protected class most likely is harassment. It could come in the form of jokes. Whereas the phrase, "oh, I was just kidding," doesn't mean it's not harassment. Actions, what someone does could be harassment. I didn't put down, but pictures one might have hanging up, music one might be listening to out loud could create a harassing environment. Okay. You could be having just debates, and you could have your opinions about life, and you could be talking to someone and debating them and saying your opinions. And if those opinions are offensive to protected classes, especially if they are not related to the workplace, it could very well be harassment. And even if something is related to the workplace, and even if it is a debate that was once had in history, a historical debate or historical opinions, it could still be harassment, because there are certain things, certain debates, certain things people talk about that we don't talk about anymore. We don't debate it. It was debated, and the answer was 99% of everyone in the U.S. agrees on the answer. And this would be called like a super precedent. So even if it relates to work in the workplace, having a debate about the benefits, possible benefits of segregation, that's going to be deemed harassment, because the U.S. has had that debate, has rejected that, and now having that debate in the workplace is just offensive, because super precedent. We don't have that debate anymore. Nobody has that. So even if it sort of fits into your job and people start debating on whether Nazis are good or not, and whether the World War II had some benefits of Nazism, that could very well be, that could be offensive. And even though it's a debate in opinions, it's one that's already been done, and no reasonable person has that debate in the workplace anymore. So here's the thing. Here's the problem with anti-harassment laws. Well, here's the sticky wicket. Number one, people on over here saying there should be absolutely no laws about about harassment, and people should be able to say whatever they want, wherever they want at the workplace. Okay, that's been tried, and the country has, as a group, said we don't want that. And then over on the other side, where absolutely no one can say nothing about any protected class, and no one can offend anyone in any time, well, that can't work either, because that's a dystopian, all-powerful government thought and speech. So if it's given that it's unacceptable to let everything go, and if it's given that it is unacceptable to have an all-powerful government that says we can't say anything ever if it's in regards to a protected class, both of those can't happen. How do we figure out where along the spectrum the rules should lie? And like everything, it's complicated. It's a complicated balance of different interests and different rights. So in this simplified triangle, we've got someone's right to work without being insulted because of their class. And we have created this as a right. First came someone has a right to work without being discriminated against because of something they can't control. And then it moved into and morphed into someone has a right to go to work and not be insulted for their protected class. But we also have the rights of humans interacting. It is true that humans are social beings. It is true that when humans work together, they interact socially, and they have throughout history. I tend to believe work should be for work, and the conversation should be about work, and everything should be work-related. And people shouldn't interact all that much. Most likely, I believe that because I don't interact well with other people. I don't have friends. I don't like interacting with other people. So obviously, I would think work is for work, and you should limit your social interactions. But that is not how the rest of the world or most people are. Most people are social beings who interact. And so people have a right to interact. And we also have to balance how much power do we want to give the government to regulate our speech and punish us for our speech, because anti-harassment laws are the government setting rules of what can and cannot be said. And remember, one of the most important things in society at the founding of the country is freedom of speech. And not freedom for you to say whatever you want, but the freedom from the government punishing you from what you said. And anti-harassment laws are literally the government punishing you for what you're saying. So freedom of speech is not absolute. But how much power do we want to give the government to punish speech? We have obviously said you do not have the right to threaten someone. Give the government the power to keep people from threatening others. You do not have the right to create a dangerous situation with your speech. You cannot, they say it, you cannot lie and say there's a fire in a crowded theater and then create a stampede. That is illegal. We've given the government the power to stop that. So how much power do we want to give the government to stop people from saying things that insult protected classes? These all have to be balanced. Now, out of order, before we get to how the law balances those rights, so this is out of order, here are just some thoughts, because we do have to separate private business from government employment and schools, let's say K through 12, because that's public and this is private. We do have to bring in, if we're talking about private business, the owner's right to, for lack of a better term, allow harassment. The owner's right to let whatever they want said be said in their workplace. So that was an owner's right throughout most of the United States history. And we've seen that the right to work free of harassment is becoming larger than the owner's right to allow the harassment, but it's still a balancing act. Now, in the public schools and the public employment, it becomes a little bit easier to make an argument for a workplace free of harassment. For example, when your boss is the government, there is no owner, okay? It's a government. And just like for discrimination, when I made the argument, do you ever want a government doing discrimination? Because that has never ended well, has it? And that is the biggest argument why there should be absolutely no discrimination in government workplaces or K through 12 government schools, public education. That is just not where the founding of this country was. If you go back to 1776 and tell those people there that we're going to live in a world where the government hires millions and millions of people and the government's going to discriminate while doing it, oh no, that would never fly. That kind of government power. And so take that, government can't discriminate it as a boss. Take that the next level where the government can't allow harassment based on those protected classes either. It just doesn't work where you have government workplaces and government workforces that target groups and harass them. It's never been a good idea in history where government employees, government employers, government places, schools target groups for harassment, for targeting. It just doesn't work out ever well. And so what we get there is that the right to work free of harassment and making sure that the government as an institution doesn't hurt people has become more important as a right than someone's freedom of speech while they're working for the government. I should put that in, while they're working for the government. All right, let's get to this intricately balanced and slightly complicated balance of rights to, I'm not saying try to please everybody, but to try to stay away from too authoritarian, yet to try to get some regulations and some protections for people to not be harassed based on their protected classes. So we get the harassment test and the balancing of rights. This is a simple test to see if an action or something is harassment and whether the federal government or state governments will get involved. Does it rise to illegal harassment, which is hostile work environment? This is the balance. And you could see, not everything is harassment. And even things that are harassment aren't really, not all of them are illegal. It is not the case that you can't say anything at work. There are tests, not rules. That's one reason it's a little complicated. There's not a list of things that you can and cannot say. There is this test, and that makes it slightly complicated and a little messy, but it does preserve freedoms and rights. All these have to be true for it to be illegal. Number one, was someone offended? Many things can be said. Many things can be debated. Many jokes can be made. Many things can be listened to, or many pictures can be put up. If no one is offended, it's not harassment. So this is where even if something is really, quote, offensive, if no one involved is offended, the government has no right to punish. This is people's rights right here. Someone has to be offended, otherwise it's not harassment. But if someone is harassment, we have to continue, or if someone is offended, we have to continue the test. Does it relate to a protected class? Let's remember those protected classes for the federal government: race, color, national origin, religion, sex, age plus 40, genetic info, and disability, mental or physical. If it doesn't relate to a protected class, federal government's not going to get involved. And state government's not going to get involved usually either. So this is the other balance of right. There's only certain things, certain classes, times when the federal government would get involved. So, you know, let's say I was not a large person growing up. I was, some people would say, skinny. And so if you go to work and people are making jokes about skinny people and you want to get the federal government involved, that is not a protected class, and the federal government is not going to take that case. It is not going to be illegal harassment. Now, your company might have something against it, and let's say the schools or your post office might have rules against picking on people, but it's not going to be illegal harassment according to the federal government. It has to be protected class. Now we have another if it is a protected class, we've got another test that comes in step 3. Would a reasonable person be offended at what was said? And this is so it doesn't give people the power to be offended. So you can't just be offended at everything. That doesn't mean it's harassment. It is true that there are people that are offended really, really easily at everything. They don't have the ultimate power to determine if it's illegal harassment. It goes to, would a reasonable person be offended by what's said? Okay? And if it's not, if someone made an innocent comment, someone took offense, but no reasonable person would have ever taken offense, it's not harassment. However, if a reasonable person would be offended, yes, then if someone was offended, protected class, a reasonable other person would be offended, it is harassment. Now, is it illegal enough for the state or the federal government to get involved? Well, that's number 4. Is it severe enough or often enough to be illegal? It must be really bad 1 or 2 times, or it could be not so bad a lot of times and you get a hostile work environment. And if it's not, the government's not going to get involved. And if it is, then we have illegal harassment. Now, one of the ways I usually define hostile work environment is it often enough? Is it bad enough? Is it, even if it's not often, is it severe enough? I picture it this way. Do you get on the you wake up and you just say to yourself, you're on the edge of the bed, I don't want to go in today. They're going to say it. They're going to say it again. They're going to talk about my fill in the protected class. Or maybe it hasn't happened for a week or 2 weeks, but you're still on the edge of the bed going, is today going to be the day? Are they going to do it that bad again? It's been a week. Are they going to do it again? When you're sitting on the edge of the bed before you go into work, worried about someone saying it again or doing it again, it's probably got to that hostile work environment level. And that is the basics, thoughts behind anti-harassment laws on the state and federal level, plus the slightly complicated yet pretty straightforward test to see if, one, something is harassment, and two, if it rises to the level of illegal hostile work environment. Okay, so having a test for harassment and hostile work environment is all well and good, but the whole situation is more complicated than a 20-minute instructional video, because hundreds of different cases have been brought up. Case law and precedent has been set. There's many different other rules involved over the years, and the complexity of the whole issue has grown. And it takes longer to delve into it, but the more you delve into it, the more you realize how the system works. So I put together some points and considerations. Each one of these is a jumping off point for something else to look into. Well, let's just go right through some of them, and I'll explain. Bullet. Intent doesn't matter. It literally doesn't matter if someone's intending to harass, intending to be insulting, or not. See, look at that test. Is there ever a point in that test where it says, what did the person intend? Did the person intend to be insulting or not? No. So intent doesn't matter. It's only the result. Now, sometimes they say it only matters if someone's offended. Well, that's not true. And you know that from the test. It has a reasonable person would have to be offended, and it has to be on a protected class. Intent doesn't matter, though. Although intent might help out if you're facing punishment, okay? It is absolutely true that someone who's doing harassing to be mean is going to get punished harsher than someone who accidentally does harassment, okay? The harassed person does not have to be in the conversation. This could be somebody walking by and seeing a picture, and you would say, that picture's not meant for it. Doesn't matter. Saw the picture. Walking by, hear someone tell a joke. Well, you weren't part of this conversation. Doesn't matter. I'm walking by and I heard it. I wasn't talking to you. Doesn't matter. I heard it. I was affected. Okay, so the person doesn't have to be in the conversation. Oh, and here's one that some people just absolutely refuse to believe this one. Even when they see the actual rules written down. The person does not have to say no, or to say stop, or to say they're bothered. No one has to say that they're being offended. You can sit there, even if people smile, that could be a nervous smile. No one has to say they're offended. No one has to say no or stop. And that's one of the dangerous things too, because going back to that rule, if you're saying jokes or you're having a conversation and you think no one's offended, so you think it's not harassing, well, how good are you at telling if someone's offended? See, these are the two biggies. Number one, you never know if someone's offended. You never know if the next day or the day after someone's going to do more research and realize that maybe they were offended. And you never know who's walking behind you that will hear. Okay, so it's always better just to err on the side of be careful of what you're saying. And especially because all harassment can be punished, even if it's not illegal, even if the federal government's not going to come knocking at your door and take you to court. Your business might just straight up punish you because you broke some rule, or they don't even have to have a written rule. They could just decide they don't like what you said. Private business has a lot of rights and power. Here's one. Positive compliments and positive stereotypes can be harassment too. Look, it's really not just that someone has a right not to be made fun of. It's one of the things is your protected class, you really can't change, okay? So, someone has a right to go in and not be exposed to talk about their religion every single day. So if people are talking about their religion every single day, you have a right not to have that happen every day, even if it's good, even if it's compliments. So I get it that there's debate whether positive stereotypes and positive things can be negative and harassment and all of that. And that's a talk people can have, but what I am telling you is legally it actually can be. Hostile work environment is an actual high bar. If you were to look at case law and you were to look at the things that the government decided wasn't a hostile work environment, you might be surprised. It's really tough to actually reach a level of harassment that makes a hostile work environment. It is a little bit tough. It has to be quite a lot of small things over time or some really big things, but some things you would think that would automatically be illegal harassment really aren't. It takes quite a bit for the federal government and courts to get involved for harassment. Discrimination is different. Even the smallest businesses' decisions based on protected class is illegal. Okay, but harassment, it's a little tougher to get to illegal. But be careful, because you can be punished for things that aren't illegal just by your bosses. Harassment is still one of the top ways to get fired. Okay, so if you start being accused of harassment and you're harassing people, quite frankly, a lot of the times these companies will just want to make it go away, and there's the firing. You see what I'm saying? It is one of the top ways to get disciplined and fired. So you do want to stay away from that. These are relatively new laws, basically in the last 50 years or so. Okay, I mean, anti-discrimination laws were only within the last 50 years and stuff, and harassment is the next level from discrimination. So this is a very new in the grand scheme of the country. Always remember, we're going through the protected classes of the federal government. States may have more strict anti-harassment laws. An interesting thing that I found, and I don't know if anybody has ever been charged with this, but it's technically on the books for New York State. Check this out. There's actually a criminal law, a misdemeanor, that covers making fun of someone at work when there's no legitimate work-related reason. So it literally, if you're at work, it's literally against the law. It's a misdemeanor to make fun of somebody for no apparent reason, no business-related reason. So that is very interesting, but I have never heard of that law actually being enforced. I mean, but it's there on the books. If there's a charge of harassment, businesses, managers, supervisors, human resource department, whatever you have, has to investigate and respond. So if you tell the manager, that manager has to figure things out. And if they don't, and the harassment keeps going, the company can be sued also. Okay? So it's a big deal when managers, bosses, business owners, supervisors don't have recorded records of them investigating the harassment or the alleged harassment. Customers are covered. So if I'm a customer and an employee harasses me, I could go to that employee's boss and make a complaint of harassment. So customers are allowed to be free, the right to be free from harassment. Okay? Employees are protected from customers. So employees are legally protected from harassment for customers. Well, what does that mean? That means if an employee is being harassed by customers, that employee has the right to go to their managers and say, you have to stop this from happening because I'm being repeatedly harassed at work from customers. And then the managers have to do something, investigate, and they have to prevent it. Otherwise, they could be legally liable. And customers are protected from harassment from other customers. It's the business has a responsibility if there's harassment from customer to customer to address it and put in procedures to protect their customers from harassment from other customers. Now, those are just a few points and a few considerations. Give me another 10 minutes, I'll come up with another 10. It's the rabbit hole is deep, but it is interesting. It is interesting. All right, thanks for watching.